Welcome back to 1-800-THE-WOLF Accident Attorneys. I'm Abby, and today I'm here with Aaron Siddique from 1-800-THE-WOLF Accident Attorneys.
Hey, Abby, so excited to be here. Thank you guys for having me.
Thanks for being here today. So Fort Worth sits at the heart of one of the busiest freeway networks in America. I-35 West, I-30, and I-820 carry millions of commuters every week, and the accident numbers reflect that. If you have been in a wreck anywhere in Tarrant County, this episode breaks down every step from the scene to Texas's fault-based insurance system to the courtroom if it gets that far. Getting hit on I-35 West during rush hour with cars flying past at 70 miles an hour is a completely different situation than a parking lot fender bender. So what should you do immediately after a car accident in Fort Worth to protect your claim?
Well, this is an interesting one. And actually, this has happened to me personally. I was rear-ended on I-35 in Fort Worth. And so not only from the legal perspective, but from my personal perspective, I'll tell you, safety is first. If you've been in an accident, it could be compounded by the further existing danger. There's cars, like you said, flying down I-35. So first and foremost, make sure if you've been in that unfortunate situation that you move to a safe location. So roads like I-35, I-30, I-820, they're notorious for this. Accidents happen there every day. And then call 911. Whether they dispatch officers or not, the phone call itself creates an official documentation or record of what you're saying. So when we don't have police reports, we rely on that often. We get the 911 calls, and those recorded calls are proof that it was made. When you make that call, dispatch will route these calls to the Fort Worth Police Department, Texas Department of Public Safety for highways, and even the Tarrant County Sheriff's Office for unincorporated areas. So that triggers help. Help is on the way, okay? And then if you're able and you're not so severely injured, I would suggest documenting the scene. Take photos, take videos of both vehicles, the road conditions, traffic signs, skid marks, any visible injuries, anything and everything. Your job is to be a journalist in a war zone. And if the other person hasn't been taken by ambulance or you haven't been loaded into the ambulance, make it a point to exchange information with the other driver. You're going to need their name, photograph of their driver's license, their insurance card, even their vehicle description, and be aware of your surroundings. This is really important. I think when people are in an accident, there's this fight or flight reaction and some tunnel vision, but try to be aware and look for any potential witnesses. Often Good Samaritans will stop, and they may not say anything if they see that you're okay, but go talk to those witnesses, ask what they saw, get their information, including their phone number and their email address. Sometimes people won't answer calls or texts, but they'll answer email. And then this is very critical for preserving your ability to make a claim. Seek medical treatment right away. So Fort Worth has tons of available options. There's the JPS Health Network, Texas Health Harris Methodist Hospital in Fort Worth is a big one, or even your nearest ER. You can find one on virtually every corner these days. Even if you feel fine, accidents that occur on the highway, I-35, I-30, you may be so jacked up on adrenaline that you don't realize you're hurt, and you need a medical professional to evaluate and document that. And if you're not hurt, they'll document that as well. And then finally, I would say one of the most important things is don't admit fault. Humans have this natural tendency when things aren't going right to apologize. At least some people do. And time and time again, we do these depositions in litigation, and the other attorney will ask, well, if you weren't at fault, why did you apologize? So don't say you're sorry. You're not an accident reconstruction expert. You don't know if you were at fault or not, or maybe you do. Maybe it's clear, but saying I'm sorry signals that you had some portion of fault, and that can be used against you in Texas's fault-based system.
Yeah, Texas has its own reporting rules that are separate from the police showing up at the scene. So are you legally required to report every accident in Texas? And what are the actual rules?
That's a great question. So I'll break that down for you. So Texas requires reporting accidents involving injury, death, or property damage that makes your vehicle unable to be driven safely. So not every accident necessarily qualifies for that reporting threshold, but most. So if your vehicle's totaled, if it's not drivable, if someone was injured, if someone was killed. So I think the key there is involving injury. If you feel anything that deviates from your normal baseline, that would qualify for injury. And Texas has a couple of different forms when it comes to this. You'll hear numbers like the CR-2 driver's report. If an officer didn't show up and investigate the crash, drivers are required to file the CR-2 crash report. It's a blue form with TxDOT within 10 days of the accident. And this can actually be done online. So back in the old days, you had to go and you had to file paper, but TxDOT has streamlined it. So you can check on the TxDOT's website. When an officer does respond, they fill out what's known as a CR-3 officer's report. They file that with TxDOT as well. So both of these reports can be really relevant to your claim. And there are some penalties under the Texas Transportation Code that kick in if you fail to file the required report. And additionally, beyond the reporting requirements, you should be reporting to your own insurance company. Notify your insurer right away. Most insurance policies have notice requirements. And if you fail to tell your own insurance company within a certain amount of time based on your policy, they could deny your claim altogether. You might not get your vehicle fixed. You might not get compensation for your injuries. And I would say this, don't minimize what's happened in the accident. Even minor things should be reported. A lot of times damage estimates are wrong at the scene. You're going to look at a vehicle, you're going to look at a person because they're upright, and they're going to say, maybe I don't need to mention that I have this headache, but that headache is a result of a herniated disc that's impinging a nerve. So in that context at the scene, you may not know how serious it was, later to only find out, failed to report it, and they're going to blame it on something else later on. So I think all of those things are very important in the context of reporting after you've been in an accident.
Yeah, the adrenaline after a freeway collision can mask injuries for hours or even days. So where should someone in Fort Worth go for medical care after a crash, even if they feel fine?
Yeah, I just want to, you said something really important there, Abby. Adrenaline masks injuries. Absolutely. I want to repeat that for the people in the back of the room. Whiplash, concussions, internal injuries surface days later once that adrenaline wears off. We're humans. We have fight or flight response that's designed to protect you from dying, but absolutely. And if you've been in an accident, I've mentioned this before, Fort Worth has a ton of great medical providers, level 1 trauma centers. JPS Health Network is Tarrant County's level 1 trauma center, and it's the regional public hospital for serious crash injuries. Tons of other options. Texas Health, Harris Methodist Hospital in Fort Worth. We have Medical City in Fort Worth. And if you were involved in an accident with your children, Cook's Children's Medical Center is one of the best in the country. I say that out of personal experience. They have treated my children. So any type of pediatric trauma, I would say the children should be being evaluated at Cook's Children's Medical Center. They have different parts of Fort Worth. They have different regional clinics there. And kind of our rule of thumb here in this office is maybe it's not practical for you to go get treatment right away after the accident. Maybe maybe your vehicle was still drivable and you have that kind of nagging dull pain. Don't let it linger too long. We have a 72-hour window rule. We advise all of our clients to seek medical evaluation within 72 hours. And I'll tell you, insurance adjusters love to key in on this. If there's a gap in the treatment timeline, it hurts credibility, right? The insurance adjusters routinely say to us, if your client was so injured or so hurt, why did they wait a week to go get treatment? And we've all been there. Life gets in the way. But in the context of this, it should be a priority. So 72-hour window. And then along with seeking medical treatment, I think it's really important that you maintain consistency with the documentation. So your medical records will directly link those injuries to the accident and form the basis of your damages claim. So if you're seeking medical treatment, that documentation will create a chronological timeline that we can help kind of dispel that notion from the skeptical insurance companies that are going to say, hey, this delay in seeking medical treatment means you weren't really hurt.
Yeah, well said. So to summarize kind of what we've gone over, the immediate priorities are safety, call 911, documentation, and medical care, even if nothing hurts yet. Plus the CR2 form if no officer filed a report. So in a metro this big, understanding how fault works can make or break a claim. So how does Texas's fault-based insurance system actually work when it comes to car accident claims?
Yeah, so Texas is a fault state, and different states have different rules. There's comparative fault, there's modified comparative fault. Texas is a fault state, and in this system that we have here, the at-fault driver's insurance company pays for damages, and based on the framework established under Texas law as enacted by the Texas legislature. So I'll just kind of walk you through the process, and we can talk about the nuance of that as it comes up. Basically, an injured party files a claim against the at-fault driver's liability insurance. In Texas, which is compared to some other states, no PIP is required. PIP is personal injury protection benefits. Texas law does not require those personal injury protection benefits, unlike no-fault states. And a no-fault state like Florida, for example, there's going to be mandatory personal injury protection benefits. However, it is optional in Texas. And so in Texas, insurance companies must offer you this in writing, and then you would have to waive that coverage. And I'm going to tell you right here, right now, for the few dollars that you're going to pay for PIP, it's worth getting it. Don't waive your personal injury protection benefits. It is absolutely a value add and a bonus whether you're in an accident or not. First party option. So kind of moving on from PIP, you can also file through your own insurance company and then have them engage in what's known as subrogation against the at-fault party. If you are okay with paying your deductible when it comes to your property damage, the first party option, in my opinion, is a really good one. Your insurance company is required contractually to deal with you in good faith, and you have some extra protections there. So if you can afford to pay that deductible, which they will go get back for you, file the claim through your own insurance company. That's called the first party option. And then what happens is there's a fault determination. How the insurance companies, how do they determine fault? So they're going to look at a number of things. They're going to look at the police report. And a lot of time that's dispositive. They're going to take that kind of neutral investigator's opinion, and they're going to look at the facts there, and they're going to decide who's at fault. And so the determination of fault should happen according to the Texas Insurance Code within a reasonable amount of time. And that's being made by an insurance adjuster who's doing an investigation. So again, going back to when we talked about the scene of the accident, documenting everything and being careful what you say are really critical at this stage of fault determination. And they're going to talk to both parties. Sometimes they're going to ask for written statements. And then who governs this? In Texas, when you're dealing with insurance companies, they have to answer to somebody, not just us, not just the lawyers. We're going to make them answer to us, but the Texas Department of Insurance, or more commonly referred to as TDI, they oversee insurance carriers operating in the state, but they don't adjudicate fault. So you'll hear this term sometimes like, oh, what's up with TDI, or you should report this to TDI. If an insurance company is acting in bad faith, you would or could or potentially would report them for failure to pay promptly, to investigate fairly, and that's kind of their governing or their oversight board. So that's kind of the insurance framework as it stands in the state of Texas, and a little bit about the process in a nutshell.
Yeah, a lot of drivers on the road right now are carrying the bare minimum, and it's not much. So what are Texas's minimum auto insurance requirements, and why do they matter if you are the one filing a claim?
Yeah, so the state of Texas requires every driver to carry the minimum liability coverage for third parties, meaning if they get in an accident for other people. And a lot of people don't know, but the limits are $30,000. So we call this, policies are written with three numbers. It's the per person limit, the per accident limit, and then the property damage limit. So you may have heard an attorney say, oh, they have a minimum policy. What they're referring to is a 30-60 or a 30-60-25. And what that means is Texas has stated the minimum liability coverage per person that your insurance would pay if someone was injured is $30,000 for bodily injury. And then in the whole accident, let's say there were more than one person, that policy would be capped at $60,000. That's that second number. And then that last number, 25, is the amount of property damage. So almost every time this is wholly insufficient. I mean, I don't think that new cars cost less than $25,000 these days. You're talking $30,000 to $50,000 on an average new car. Maybe you can get something used. So $25,000 is often insufficient. And then if you are in an accident and you go to JPS Health Network or you go to Texas Health Harris Methodist Hospital in Fort Worth, your initial trauma workup or evaluation could easily exceed $30,000. And so if the at-fault driver only carries that minimum, you could potentially be capped in your recovery at that $30,000. We see that a lot here. I will say, and this, if you take anything away from anything we talk about today. I'll scream it from the rooftops. In my opinion, the single most important coverage that you can get to protect yourself is UM or UIM coverage. What does that stand for? It's uninsured and underinsured motorist coverage. It fills the gap between the Texas Insurance Code required minimum, and it allows you to go to your own policy to recover the excess that may not have been covered by that uninsured or underinsured driver. In Texas, just like with the PIP benefits, they're required to offer it to you in writing, but they're not going to sell it to you. You know, this one is one that they end up paying out more on. And so it kind of goes against their business model. So PIP and then this UM coverage has to be waived in writing. And so one of the things we do here at this law firm, and if they didn't offer it to you in writing and have signed rejects, we can often force them to provide that coverage for you. But when you sign up or you renew your insurance, please make sure you're looking at the UM or UIM coverage along with your PIP benefits. You may not even fully understand what I'm talking about, but trust me when I say you need both of those coverages. And then beyond that, in terms of insurance, like I think one thing that's worth noting is, registration linking. The Texas DMV requires proof of insurance to register your vehicle, but just having registration doesn't mean that the policy is still active. And we'll see it time and time again that people will get into an accident. Defendants will provide our clients with an insurance card because they had it at one time, but maybe it lapsed for lack of payment. So they got their vehicle registered when they had insurance and then it lapsed. So that UM is really important to protect you in that circumstance. Otherwise, there may not be a way to even get your vehicle repaired if you yourself don't carry full coverage.
When multiple vehicles pile up on I-35 West or in a I-820 construction zone, figuring out who is at fault gets complicated fast. So how does Texas's modified comparative negligence rule affect a car accident claim in Fort Worth?
So we touched on this a little bit before, Abby. You asked me a question earlier about the fault system, and I mentioned that some states have modified comparative negligence or modified comparative fault. It's not just black and white. You did it or you did it or you didn't. So Texas does follow the modified comparative negligence rule, and that means you are entitled to recover as long as you're not more than 50% at fault. Okay. So the hard cutoff is 51%. If you are determined to be more than 51% at fault, you're completely barred from recovery under the Texas Civil Practices and Remedy Code. I believe the section is 33.001, and this is called the 51% bar rule. So it gets a little complex, but just know this, like you could be 50-50 and still recover. But if you are even 1% more at fault, you can recover nothing. And if you were 50-50 and say your damages were $10,000, then they're going to basically give you what percentage the other person was at fault. So we can walk through some more detailed kind of examples on that, but I was just throwing it out. Hard cutoffs 51%. That's what's important to remember. And basically your damages are going to be reduced by your percentage of fault. So if you were found to be 20% at fault, that means your damages are going to be reduced by that, and you're going to be paid 80%. So let's say you had $100,000 in damage. You were faulted at, you were put at 30% at fault. That means you're only getting $70,000 in that situation. But if you were 51% at fault, you would get zero. And insurance companies, this is like a tactic that they use in basic scenarios. It's like, no, I had the right of way and that guy pulled out in front of me. Well, the insurance company are going to employ these dirty tactics, and they're going to say, well, my client said that you were speeding. So because you were speeding, you actually had some contributory fault. You had some comparative negligence. And they're going to try to find a way to push that up to where a jury could consider it. And they're going to try to make you 51% at fault and to bar your claim entirely. But the good news is we have a system. It's not a perfect system. In our civil courts, just like in our criminal courts, a jury gets to decide ultimately. So if the case goes to trial in Tarrant County District Court or the Tarrant County Court at Law, the jury is going to assign the fault percentage. And so that's why it's really important going back. I keep going back and talking about all those things we talked about at the beginning to document the scene of the accident, to not say that you're sorry when you don't know what's happened, to document your injuries, and to preserve as much evidence so that we can go out in Tarrant County District Court, if that's where we choose to file, or the county court at law, and prove your case for you.
Yeah, that is some great advice and a great explanation. So let's say then the accident is over and the paperwork is piling up and most people have no idea where to start. So how do you actually file an insurance claim step by step in Texas, and who should you contact first?
These are really complicated, complex situations. As based on everything we've talked about. And so I would say call us first. We can make sure you don't step on any landmines and guide you through the process. No fee consultation. And even if you choose to bring us on to assist, we're going to kind of point you in the right direction. But I'm going to give you that advice here now. And then if you feel like if you're listening or watching and you feel like you need a little hand holding, that's what we do. But first and foremost, whether we're doing it or you're doing it, you're going to want to notify your insurer first. Texas policies do have prompt notice requirements. All of these contracts for insurance state that. So call the most important one first, which is your insurance company. I know like the instinct is going to be like, F that, this guy hits me. I don't want to call my insurance company. They need to know, because if you have to fall back on that policy and you haven't notified them because the other person was at fault, create a problem for you later. Then I would do kind of the second or third step. If you've called us first, we're doing this for you. But if you're doing it yourself, you're going to need to file a third-party claim. What that means is the other driver who was at fault, you're going to file a claim against their insurance or with their insurance company. And then they're going to give you a claim number, and you're going to need to write that down because they're going to reference it and they're going to ask you on every single call. That's kind of your key to get back into the house there to talk about your claim. And then what are you providing? Whether it's your own insurance company or it's a third-party insurance company, you're going to give them any police report numbers or those TxDOT report numbers, any photos, any medical records. If you were listening and paying attention at the beginning and you got that witness information, now's the time to turn it over. You're going to give them the CR-2 crash report if it was filed with TxDOT. And so those are kind of the base documents and things that you're going to provide. But I want to pause here. Another lawyer red flag. We're going to want to make sure that you guys do not give a recorded statement to the other party without an attorney present. And this, if it's already happened, it's happened. Like there's ways to mitigate that. But I'll say that these recorded statements are designed to lock in a version of your events, and they are designed to ask questions to make you feel comfortable, to get you to commit to a version of events that could later be used against you. So don't do a recorded statement. It's okay to say no. And sometimes it feels like a little adversarial. It is. Although insurance adjusters are designed to make you feel comfortable and get you talking, to extract as much information out of you as possible, resist the temptation. They're going to be nice. They're going to be your friend, but they're not. Their entire business model and their jobs depend on taking in more money than they pay out. So be careful about the recorded statements. After that, I'm skipping a few steps here, but we would, or you should, submit a demand letter once you've reached what we call MMI, or maximum medical improvement. Okay. That's the point in which you are not getting better or worse. It's either back to your old baseline or you're at your new baseline. So we call that an MMI. If the doctor's told you you're at your maximum medical improvement, it's time to send that demand. And then I mentioned earlier, if you make the claim with your own insurance company and they're not treating you fairly, you have some additional claims. So the Texas Department of Insurance allows for help in a situation where insurers are acting in bad faith. And then the Texas Insurance Code provides specific protections against unfair claim settlement practices. So if you have the ability, that's why I say, and those are more for the first party claims, do that first, or have us do it for you.
Yeah, that first phone call from the adjuster usually comes within a day or two, and they are recording every word. So what should a Fort Worth car accident victim expect when the adjuster calls, and what should they absolutely not do? I know you touched on this a little bit, but if you want to expand a little bit on what that conversation looks like.
Yeah, adjuster loyalty, okay? The L word. Who are they loyal to you? Who are they loyal to? If you think they're loyal to you, you're wrong. They work for the insurance company. The insurance company is not a service provider. They're not the government. They're not there to give you a handout. Their entire goal is to minimize payouts and to act like they're helping you, but ultimately not help you and pay you the least. So some of the ways that they're going to get you to do that, they're going to try to get you to do the recorded statement. We talked about that earlier. No, take this away. This is one of the key takeaways. No recorded statement. Avoid giving the recorded statement, particularly to the other driver's insurer, without your attorney present. If you decide to go at this alone, and I wouldn't suggest it, but if you do, don't take their first offer. We don't. It's almost always a low ball, right? And they're going to ask, because you know how many people say, oh my goodness, like $500, sure, I'll take that, or $1,000. It may feel like a lot of money to you at the time, and they're banking on that. They're playing on your emotions. One of the other ways they kind of try to get you outside of a quick lowball settlement, they'll call you up and say, hey, this seemed relatively minor, so they're already minimizing it. You haven't been to the doctor yet. We're going to give you $1,000. You go get checked out. Sign this release. Sign this medical release so we can get all your medical records. No, we're not doing that. Do not sign a blanket medical release. So you guys have heard the term delay, deny, depose. So these are very common tactics by insurance companies, not just health insurance companies, but car accident insurance companies. They're going to delay. They're going to take as long as possible so that maybe you don't seek medical care. They're going to deny that their insured was at fault based on some lie. They're going to blame you for a higher percentage of fault and to try to push you past that 51% bar and eliminate your claim entirely. And so we see it time and time again. And even if they don't try to push you past that 51% bar, they're going to try to hit you with you're 30% at fault because you were speeding. How could they even prove that? They're not accident reconstruction experts. It's because it's a business strategy. Delay, deny, and blame. Fortunately, we do have some protections here in Texas. The Texas Department of Insurance does enforce the Texas Insurance Code provisions against unfair settlement practices. So we can always report them to TDI or the Texas Department of Insurance. And if it's your insurance company giving you the runaround, we can also bring a bad faith claim on your behalf.
All right, we have covered Texas's fault system, the 30, 60, 25 minimums, comparative negligence, and with the 51% bar, and how to handle the insurance company. So people get caught up in doctor's appointments and insurance calls and forget there is a hard deadline running in the background. So how long does someone in Fort Worth actually have to file a car accident claim under Texas law?
Short answer is 2 years. So 2 years for personal injury, and it's also actually 2 years for property damage. So the statute of limitations, meaning the time in which you have to bring your claim in Texas, is 2 years starting from the date of the accident. And that's under the Texas Civil Practice and Remedies Code, Section 16.00. You can go look that up if you want to read it for yourself. But there's also 2 years for property damage claims. If you go beyond that, the state has basically said, look, we believe if you're sleeping on your claim this long, that people shouldn't have to look over their shoulders. We're not going to let you bring it. So if you did try to bring it, it would get tossed out of court after 2 years. So that's for personal injury, 2 years. For property damage, it's 2 years. And then something that unfortunately we've dealt with quite a bit over these last few years are wrongful death cases. The same 2-year statute limitation window applies. And it's a hard deadline. If you miss it, the Texas Judicial Branch is just going to dismiss your case. No exceptions. It's what's known as summary judgment. The defense attorney will file a motion for summary judgment. Not only that, you could get hit with attorney's fees potentially. That kind of brings up court procedures. Cases filed in Tarrant County District Court or Tarrant County County Court at Law, they follow the same 2-year rule, but there are procedural requirements and preparation time. So as long as we get those cases filed before that 2-year date, we're okay. And this is another common misconception as well. People will file an insurance claim thinking that pauses the statute of limitations. It does not. It keeps rolling. So when you file an insurance claim, it does not stop or pause the statute of limitations clock. So a rule of thumb in our office, just to be safe, because filing lawsuits is complex business. You have to make sure you're suing the right defendants, the right corporate entities. We need time. So we consider at about 1.5 years, that's our drop dead. If we're still negotiating a claim, when we're 6 months out from that statute of limitation, we're gathering information, getting ready to file. You don't want to wait until the last day. I mean, it happens, but you should take action on your claim right away.
There is one exception that cuts the timeline down to 6 months, and it catches people completely off guard. So are there situations in Texas where the filing deadline gets extended or shortened?
Yes. So there are, as with everything, there's a few exceptions to the general rule of thumb, the 2-year rule. One in particular is minors. The statute would be tolled until the child turns 18, and then the 2-year clock would start. And when I say toll, I mean stop. That's all. That's just fancy legal jargon for toll. So for a minor, even if they're injured when they're 12 years old, the statute is tolled until they're 18, and then they have 2 years after they turn 18 to bring the claim. So if you've had a kid that was in an accident and they received treatment, even if it was when they were 11, 8, 7, 6, they have 2 years until after they're 18. And then there are some other deadlines and timelines to be aware of, particularly when it comes to governmental entities. So Texas has something called the Texas Tort Claims Act. And under that, you are required, if you're involved in an accident with a government employee, or maybe like the city of Fort Worth or the Tarrant County government or TxDOT or any other state or local government, that Texas Tort Claims Act requires you to give notice of your injury and claim within 6 months, or your case could be barred. So 6 months is, in that circumstance, you still have 2 years to bring your claim, but you have 6 months to give them notice. So 6 months is fatal. If you miss that governmental notice deadline, it'll kill your claim. And we've had cases where this, and you got to think about this, unexperienced attorneys that aren't aware of these deadlines, they've had your case, they don't notify, maybe a sheriff officer ran a red light and struck and killed someone in an intersection, and you don't notify them within 6 months and you can't bring that claim. That's double tragedy. You know, it's compounding. So 6 months rule. And then beyond that, there's a couple more. So the discovery rule in Texas, and this is very rare, the clock to bring your claim would not start until basically the injury is discovered, not when the accident happened. And so Texas courts really interpret this narrowly. And where we've seen it come up, it's not necessarily in the context of the car accident, because if you get in a car crash, you're going to know that you're injured pretty quickly. It's more so in things like where we have medical malpractice claims, where maybe a doctor performed a surgery or, left some sort of mesh or surgical tool or instrument behind, and you don't really discover it until 6-7 months later, or 2 years later, or 3 years later. The law is not going to penalize you for that. They'll say on the day you discovered that this injury occurred, the clock starts ticking there, and that's 2 years from that date. And then one more, mental incapacity. Maybe you were incapacitated during that statute. Potentially, it could be told if you had some sort of mental incapacity, and that's all governed by the Texas Civil Practices and Remedies Codes. There's some narrow carve-outs there, but I won't bore you with them.
Fort Worth has traffic cameras at every major intersection, and the footage does not stick around forever. So what evidence matters most for a car accident claim in Fort Worth?
All evidence carries different weight, and some is more probative than others, but all of it is, in my opinion, is equally important. That's why the information gathering on the front end and expeditiously is critical. So say you go to the wrong law firm, or you try to do it yourself, and you miss requesting some of these things, could really impact your case. So the foundation is a police report. We get those from the Fort Worth Police Department or the Texas Department of Public Safety. It's the foundation. It carries significant weight with the adjusters and juries in Tarrant County. Well, more so the adjusters. Traffic cameras, that's kind of an area where people miss a lot. Fort Worth has traffic cameras at major intersections along I-35 and I-30, and that footage has to be requested if it's available before it gets overwritten. That's one of those deals where you have to know how, where, when, and you have to do it quickly. Other evidence that we think is really important here that often gets overlooked, witness statements. Get them at the scene before people leave. Ask if they're okay if you just film them talking about what happened. You don't have to write it down, but make sure you get a couple of different ways to contact them. People change their phone number, people move, but usually people's emails stay the same. So try to get a couple of different ways to get in contact with your witnesses. Something that we're looking at right now in a case where a young lady was killed, cell phone records. They can prove or disprove distracted driving. And sometimes it's a fight to get them, but they're increasingly subpoenaed. So cell phone records are one. Medical records, because we're usually fighting about injuries, are a battleground. They have to show a clear and causal connection to the accident. The mecha, basically, if you're treating somewhere, you have to have a competent doctor that understands the mechanism of injury and relating that back to the date of accident, to the injury that occurred. So medical records is a big one. And from time to time, we're hiring accident reconstruction experts. They're critical for serious and disputed crashes. A lot of time we see that in the context of commercial cases. So National Highway Traffic Safety Administration crash pattern data helps us to frame up the liability picture a lot. And dash cam footage, Teslas have them now built in. A lot of people, a lot of drivers, a lot of our clients are savvy and they own dash cams, or we find them on nearby vehicles. That's why it's important to get the witness statement. Maybe a witness had a dash cam. And so that's footage that no one can argue with. We've had really helpful dash cam footage in commercial cases, 18-wheeler cases involving Teslas that resulted in policy limit settlements because we were able to access that.
That is some great advice, and thank you for that. So can you explain what someone can actually recover in a car accident claim in Texas?
Absolutely. I think that's a great question because that really gets to the root of how we right these wrongs. And our system's not a perfect one, but the only way that it's designed to fix it is through an award of money damages. So a lot of my clients would rather, have their health back, but the only thing that we can do is money damages. And that's kind of broken down into a handful of categories. And so I'll run through them and then I'll go through and talk about each one in a little more detail. So you have economic damages, you have non-economic damages, then you have caps that apply to them. You have what's known as exemplary damages, and then you have special damages for things like wrongful death and for property. So going to taking it from the top, the biggest category is the economic damages. That's going to be things like your medical bills, but that includes both past medical bills and future medical bills. So the right attorney, the right doctor will know how to quantify that and preserve that data for you. Economic damages also include lost wages, things like diminished earning capacity. Maybe you're not able to work the same way that you did before. It would also include the category we talked about as one-offs, property damage, and then any out-of-pocket expenses, hard costs that, rental car reimbursement, things of that nature. And then non-economic damages. This is one that's often fought about. They'll fight about economic damages. They'll say your medical bills were too high, but that's usually black and white. Non-economic damages. This is your pain and suffering. This is your loss of enjoyment of life. This is your mental anguish. If you've been disfigured, there's some mental traumas that are carried there. And the Texas Judicial Branch in car accident cases does not cap non-economic damages in most personal injury cases. Medical malpractice is separate, so we're not going to talk about that. And Texas does not cap economic damages. The Texas legislature has left economic damage recovery uncapped, so that's a good thing. There have been some attempts at limiting those in the legislature, but fortunately, the judicial branch has stepped up. Exemplary damages, okay? Texas calls them exemplary damages, but what they really are, they're available in cases of gross negligence, like drunk driving or extreme recklessness. We see juries being asked to award exemplary damages and awarding them in these extremely egregious cases, and they're meant to deter and to punish. And so sometimes those can be really, really high, particularly in drunk driving cases. And then some of the things that kind of encompass all of those, we touched on it, wrongful death. We handle a lot of wrongful death cases, but you can recover for funeral costs, loss of income, loss of companionship, mental anguish, and you can typically recover if you have standing, meaning a spouse, a surviving parent, or a child of the deceased. But that's all governed under the Texas Civil Practices and Remedies Code as well. And then we talked about property damage. That is straightforward, but a lot of times it's undervalued. The insurer's market value offer is usually lower than actual replacement cost, but that's all dictated by the insurance code. And so it's really hard to kind of, you get close. And so it's just one of those things, but property damage is another one.
Fort Worth sits inside one of the largest metro areas in America with massive freeway volume and a commuter pattern that runs from dawn to dark. So what makes Fort Worth car accidents different from other cities, and how do those local factors affect claims?
Fort Worth, and particularly, the Dallas-Fort Worth Metroplex, is one of the most densely populated in our country. In North America even, so if you plucked out the top 20 cities, they're gonna land in there. And so one of the things that does from a logistics standpoint is it creates really heavy freeway volume. So I-35W, it runs straight through downtown Fort Worth. And then I-820, if you're not from here, even if you're from here and you haven't really thought about it, I-820 loop wraps the city. And then I-30 carries all the Dallas commuters east and west. And they all see massive volumes daily. And then not to mention, you have freeways like 183, 114, 121 that aren't as heavily trafficked, but are as heavily trafficked, So the commuter sprawl, the DFW Metroplex spreads accidents across a huge geography with longer commutes and higher speed exposure. So when people are trying to get from Fort Worth to Dallas or from the suburbs into downtown Fort Worth, if you're coming in from Euless or Grapevine or Colleyville or Haltom City or North Richland Hills or Keller, like these all make up Tarrant County, which is Fort Worth, and people have to get to and from. And then you layer that with the crazy construction zones. TxDOT's got construction on I-35 it feels like every day. They've got construction on I-820. It just creates constant shifting lane patterns and work zone hazards basically all through through the TxDOT Fort Worth district. So kind of in my opinion on that is people travel these roads every day. And even if they're traveling at a safe speed, there's millions of people. The traffic patterns are changing. The streets are under construction. There's always a hazard. Then you mix in the weather. It's crazy. And then, the other thing that we didn't talk about is toll road traffic. The North Texas Tollway Authority, they operate the major toll roads connecting Dallas and Fort Worth, and toll road crash data may be relevant to this conversation as well. A couple of other things I think that kind of touch on what you're asking is uninsured drivers. We mentioned, I believe that the single most important coverage is UM or UIM coverage, uninsured motorist or underinsured motorist coverage, because Texas, unfortunately, has one of the higher rates of uninsured drivers in the country. That's just a fact. And you would think that the insurance companies or the state would require this uninsured motorist coverage to be mandatory, but they don't. So you really got to make sure you check your policies. And then one of the other things that we see come up is government liability. Like if there's a road defect or a signage failure that caused an accident, TxDOT or the city of Fort Worth or Tarrant County government may be liable. Don't forget, you have a 6-month notice requirement under the Texas Tort Claims Act, but there are also things that could prevent liability. They are protected by sovereign immunity in certain cases. And interestingly enough, one of the things that the Texas Tort Claim Act does, it's the city actually, or the government, Fort Worth, Tarrant County, Texas, waiving their sovereign immunity so that you can sue them. So they've done that voluntarily. So that's why that 6-month notice requirement is really important.
So we have covered the legal deadlines, the evidence you need, what you can recover, and what makes Fort Worth accidents unique. Now let's talk about finding the right attorney and whether to settle or go to court in Tarrant County. So with the 51% fault bar in Texas, having someone fighting for your side from the beginning matters more than most people realize. When should someone in Fort Worth actually pick up the phone and call a car accident attorney?
I mean, shoot, call me from the scene of the accident. Right attorney right here. There's never, the wrong time to call is after you've talked to the insurance company. So I'd say it's really important. If not, there's no obligation to hire us, and we're only here to help. And so, like I said, free consultation. If you call 1-800-THE-WOLF accident attorneys, if you call 1-800-THE-WOLF or visit 1-800-THEWOLF.com and reach out to us, we're going to walk you through this. But number one, it's critical to call before you've given any statement to the other person's insurance company. We're going to just kind of tell you what the pitfalls are, what they might ask you. We're going to prepare you. We're not going to tell you what to say, but the truth always guides, and it's important how you frame that. And then, you're going to have ongoing treatment. So it's important to call us ahead of time so that we can make some recommendations for people that we know that we've seen can document these injuries. And so if you're going to have to go to the doctor more than a single visit, you definitely need to be calling an attorney because the bills are going to rack up, and you're not going to know whether they're insured or underinsured, if you've met your notice requirements, all this kind of stuff. And then because Texas is 50, we've talked about it several times here, the 51% cutoff for modified comparative negligence really makes fault percentages critical, and you need an advocate. We are increasingly seeing it where our clients, based on our knowledge and experience and length of time in the industry, we as the attorneys can see our clients were 0% at fault, but the insurance company has keyed in on some obscure thing that maybe was coaxed out of them or was said in a recorded statement, and now they faulted my client 30%. And so I want you to think about that. If your car is going to cost $10,000 to fix, and they find some crazy thing to say that you were 30% at fault for, and instead of giving you $10,000, which enables you to fix your car, they give you $7,000. That means you have to come out of pocket $3,000 just to make whole when it wasn't your fault. So definitely when you have disputed fault, when the liability's been denied or you've been lowballed, sometimes emotions run high after an accident. You may think you're getting lowballed, maybe you're not. I don't know. But if you have been, call us. You need an attorney in those situations. And even though you might carry uninsured or uninsured motorist coverage, UM or UIM, I want to make a point about that coverage. It's important to have. But what it does is it allows your insurance company to step into the shoes of the defendant that hits you. And what does that mean? That means your insurance company is going to take the defendant's same claims and defenses against you. So you have the coverage, but now they're acting like they're the other guy's insurance company, and they're going to say, hold up, you were speeding, or, So you really need an advocate, even in an uninsured or underinsured motorist coverage situation. We take on your insurance company for you. And then free consultation. So Standard and Fort Worth, the State Bar of Texas, and the Tarrant County Bar Association both offer referral services so that you can find someone that will offer a free consultation. I'm just putting it out there. 1-800-THE-WOLF Accident Attorneys. Your consultation is always free. We have really great attorneys here who have worked for some of the largest and highest volume law firms in the state. And so I've hand selected those people that have had tons of experience, more than 10 years each for the attorneys and all the staff here as well. So provide a free consultation.
Yeah. Free consultation. Most people do not realize they can talk to an attorney without paying a dime upfront. So then how does the fee structure work if someone hires a car accident attorney in Fort Worth?
So we, 1-800-THE-WOLF Accident Attorneys and a lot of the other personal injury attorneys here in Dallas and Fort Worth offer no upfront costs. So the way we do that is through a fee structure called contingency fee arrangement. And that means you don't pay anything unless and until we recover. And typically what you do pay in that scenario is a percentage of the settlement. And all law firms in Fort Worth, in Dallas and Texas and the United States handle this differently. Rule of thumb is roughly the attorney will take 33% of the settlement, up to 35%, some up to 40% pre-suit. If you go to trial or you have to file a lawsuit, the percentage usually escalates. There's a fee escalator. It could increase up to 40% if a lawsuit is filed, sometimes even 45% if you go to trial. So that varies, but rule of thumb, 33%, 35% pre-suit, 40 or 45% if you file a lawsuit. And the other interesting thing, the good thing is people don't know that the attorneys also advance all of the costs. So they're going to front money for, and we do, for filing fees. We pay for expert witnesses. We pay to get all the medical records. That's all typically advanced by our law firm. And those things add up. You can have thousands of dollars in case expenses. And so this arrangement really works well because otherwise in a traditional setting, someone would have to come in, they'd have to pay a $5,000, $10,000, $15,000 retainer, and then they're going to have to pay for all of those costs. So before you even reached a recovery, and the recovery is never guaranteed, you might have spent 20 grand. So hiring firms under this arrangement makes a lot of sense. And it's really, it helps the clients spread the risk. And if the attorney doesn't make a recovery, read your contract carefully, because at least for us here, we spell it out in black and white. If for some reason we don't make a recovery, you owe us zero. And that's not typical. Some firms will say, we've spent $1,000 on medical records, you owe that to us. But we take your case, we fight for you, and we take that risk on alongside of you.
Tarrant County courts have their own rhythm, and the settle or trial decision is one of the biggest in any case. So how does someone decide whether to take the settlement or go to trial in Tarrant County?
So at our law firm, at 1-800-THE-WOLF Accident Attorneys, our clients are always in control. So how does someone decide whether to take the settlement or go to trial in Tarrant County is going to depend. It's always going to depend on what that person's life circumstances, situation, economic duress, maybe, all these things factor in. But we look at, based on our knowledge, time, and experience in doing this, is it fair and is it reasonable and does it adequately compensate the client or make them whole? That's a conversation with the client. Some law firms don't do that. They say, hey, we got your $5,000, here it is. But some of the things to consider: settlement rate. Most car accident cases in Fort Worth, and particularly at our law firm, settle without going to trial. That number could be as high as 95% of cases. If you are with the right law firm and they are doing what they should on the front end in terms of investigating and creating and bringing value to your case, that percentage should be pretty high. And we evaluate every offer, and we're going to look at things like, does this offer cover all of the medical bills, the lost wages, the future costs, and does it do justice to the pain and suffering that my clients felt? And again, that's a conversation that we have with our clients. And touching on the future treatment, if the offer doesn't cover future medical costs and you maybe need a surgery, then we're not taking it, right? They're saying, well, they haven't had, and we see this a lot. The insurance adjuster will say, yes, you have an estimate for a surgery, but I'm not paying for that surgery unless they have it. That doesn't mean that the client doesn't need the surgery. That should be up to the client to decide. They should still be paid for that future procedure. And so we look at stuff like that. And then trial timeline. One of the things we do when we get to that juncture, if we're able to not settle a case, if we're fighting over something, usually it's value, we talk about what does going to trial in Tarrant County District Court, the Tarrant County Court at Law, look like. And that's going to add 1 to 3 years on your timeline, but it may yield a significantly higher award. And some of these insurance companies out here, I'm not going to name names, they will say stuff to us like, what do you mean that offer's too low? You haven't sued us yet, which I think is really crappy. It's basically like, we know we're lowballing you, but you haven't sued us yet. So you got to find yourself an attorney that's willing to punch them in the mouth and sue them. A couple of other things we consider too is the court in which we file in. We have options on which court we would file in, and that dictates timeline too. So smaller claims that we think you may have a value of $200,000 or less, we're going to go through the Tarrant County county court or civil court at law. Larger cases, we usually file in the Tarrant County District Court. It's because there's no jurisdictional limit, meaning how much money is, if the amount in controversy is so much, that court's limited on what they can hear. So Tarrant County District Court, there's no limits. Tarrant County Civil Court at law, smaller amount in controversy, usually a couple $100,000, but those move faster. And so if we're looking at a case where I know the value of the medical bills is $10 or $15 or $20,000, and I don't think it's going to be $1 million case, then we're going to file in the county court at law to move it through quicker. And then we look at verdict trends. So jury verdicts in Tarrant County are evaluated on a case-by-case basis through the Texas Judicial Branch. And, results really do vary by venue and fact pattern. So that's also a part of our discussion. If I have a case that occurred in Dallas County, it may not yield the same result as Tarrant County because the jury pools are inherently different, and we model both outcomes. And we do this sometimes in our demand letters. We will present data on similarly situated cases that says, look, if you don't settle with us and we have to go to trial, these are what the jury's verdicts are looking like in this county for this type of injury. Most firms don't do that, but we think that it's important data for insurance adjusters to consider. So your attorney should be modeling settlement values versus likely trial outcomes. And then that gives the client the full picture of information on how to decide their case, whether to settle or to go to trial.
So after handling hundreds of these cases, there are patterns you see over and over. So can you tell us, what are the biggest mistakes you see car accident victims in Fort Worth make that hurt their claim?
One, and it's funny because we do so well, the firm, if you don't follow us on social media, check us out. We're on Facebook, Instagram, TikTok, all those places, even LinkedIn. And we do a lot of giveaways. So the handle's Wolf of Law Street _ on Instagram. I think we just hit 75,000 followers. So shout out. But social media, right? It's good for some things. It's bad for others. It's really bad for your case. Posting about the accident. Insurance companies monitor everything. I'll give you a quick example. We had a client who was really hurt. His neck was really messed up, and he still had to live his life, and he was active on social media. His accounts were not set to private. Do not recommend. And we go to negotiate the case, and we're talking about how serious the injuries are and how they've impacted his life. And this insurance adjuster was just like, this gotcha moment. It's like, well, what about your client's Instagram? I saw your client at a music festival smiling. I saw your client skiing. And that very well could be true, but our client was also in a lot of pain. And so what you can't contextualize is how you had to fight through the pain and put a happy clown, put a little fake smile on your face to grab a photo. People don't stop living their lives, but social media really throws a wrench in it because nothing is as it seems on social media, and the insurance companies are monitoring that, and they're going to use it against you. That's a big one. The second biggest and probably most important from the outset is delays in treatment. And those what we call gaps in treatment, insurance adjusters exploit to poke holes in your case and to try to drive down the settlement value. And then admitting fault. I told you, to quote Justin Bieber, is it too late to say that I'm sorry? Don't do it. Just don't do it. No, it's never too late, but don't do it. Don't say I'm sorry. That could be used against you. And then an early settlement. I have a case. I'm absolutely crushed for this gentleman and his daughter. She was pretty severely injured, and he did not understand that the release that the insurance company asked him to sign he didn't understand that it covered everything and released the entire claim. And so he took $8,000 on a case that I believe is probably worth more than $100,000. And so again, insurance adjusters are trained to make early, quick settlement offers to prey on your vulnerability and maybe your need for short-term cash. So even if you need money, I wouldn't look at it as a lifeline. These cases and these claims, I would just put it out of the back of your mind and let us cook. But early settlement, don't do that. The CR2 form, not filing the CR2 crash report with TxDOT within 10 days as required could be a pitfall. That kind of parlays into government deadlines. Big one. Missing the 6-month notice under the Texas Tort Claims Act when TxDOT, the city of Fort Worth, or the Tarrant County government is involved. That could bar your claim. And then failing to preserve evidence. According to the National Highway Traffic and Safety Administration, crash scene evidence degrades fast. That's a fact. Traffic camera footage gets overwritten, skid marks disappear, debris gets washed away. And so it gets real hard then for our experts to come in and prove that you were 100% in the right. And maybe we're not even fighting about, 51 or 50. Maybe we're fighting about 30%. And that 30% could mean $100,000 if your claim is a serious claim or a larger one. So, and then signing blanket medical releases without your attorney reviewing. A lot of times the insurance companies will ask for that. And then they'll pour through your mental health records. They'll go get your records from your counselor, and they'll hear all about your breakup and that girl that hurt your heart and all that stuff. And they'll find a way to use it against you. So blanket releases are another one.
Between the I-35 freight corridor and rideshare drivers on every block of downtown Fort Worth, this metro has accident types you do not see in smaller cities. So how do rideshare accidents, truck crashes, commercial traffic change the claim process in Fort Worth?
So really great question, because even when people are doing the right thing, they're out, they're having a good time. They don't want to drink and drive and be one of those drunk drivers that crashes into our client and then gets hit with $1 million in exemplary damages. They get in an Uber or a Lyft or whatever, or Waymo, and then someone hits them. What does that rideshare coverage look like? It is an ever-changing regulatory landscape. And I'll tell you, the rideshare companies have become really good at changing coverages on their drivers to the point where even the drivers don't know when they're covered. Sometimes we represent the drivers as well. But rideshare coverage is going to depend on the driver's status, whether the app is off versus whether they're waiting or whether they're on an active trip. So if that driver hits you and they are en route to a trip, it's going to be different than if that driver hits you and they have somebody in the car versus if that driver is not active, but they have the app open. And so in an active trip, typically a $1 million commercial policy kicks in from Uber or Lyft or even Uber Eats. We have a case right now against Uber Eats, and it should be, these people were seriously injured. And unfortunately, that $1 million commercial policy that kicks in from Uber or Lyft is not even going to be enough to cover their damages. So that's kind of the story with Uber and Lyft. It is complex, and and there are scenarios too that are worth mentioning where the drivers are required on their own insurance policy, because they're independent contractors, to carry what's known as a livery policy that allows them to do work for hire in their car. If they don't have that coverage, then there could be denials. We've seen that. And we've seen cases where these drivers have done everything they should, and rideshare companies are trying to skirt out of paying. So these situations definitely warrant a call to an attorney that has seen a high volume of these types of cases. We have here, of course. And then kind of moving on from rideshare, just to talk about commercial trucks. That could be anything. It could be an 18-wheeler. It could be your local HVAC company. It could be somebody hauling concrete. They're regulated federally. So federal regulations from the Federal Motor Carrier Safety Administration apply. And it could pull in a lot of potential liable parties, not just including the driver, but their employers, manufacturer of products, the people shipping, so it's all over the place. And DFW, I'm sorry, I'm ranting a little bit on this topic, but DFW is Dallas and Fort Worth. It's a major freight corridor. I mean, goods are being shipped from all over the country, and they go right through Dallas and Fort Worth, particularly Fort Worth. I-35W is a major north-south freight corridor, and I-30 also carries heavy commercial traffic back and forth to Dallas. And so those trucks are subject to both the Texas Department of Public Safety oversight and federal rules. So when you're dealing with those, it's important to have an attorney who knows how they're governed, how they're regulated, and what insurance might apply. A couple more points on this question, and I'll be quiet. Toll roads, like the North Texas Tollway Authority sees commercial truck traffic. That adds another layer of records for us to go get. Evidence preservation in these types of situations has to be preserved quickly. And trucking companies have been known to destroy records, lose cameras, data goes down. They have data recorders, manipulate driver logs. So it's really critical for not just an individual that's been in one of these accidents, but for the law firm that you choose to deploy rapid investigation. And so I would say on those types of cases, contact an attorney immediately. Call 1-800-THE-WOLF, visit 1-800-THEWOLF.com, because I'm telling you, critical evidence will be gone within days.
Thank you, Aaron. You've had some great insight, and I know you've had some really important points, but for someone listening right now who has been in a car accident in Fort Worth, what is the one thing you want them to remember?
Remember me. Remember me. I'm singing Disney. I don't know, what was that? That was Coco. Yeah, remember me. Really, you need to document everything from the moment the accident happens, every single detail. And you have the most powerful tool in your pocket, in your purse, sitting on your seat next to you. It's your cell phone. Take notes, take pictures, take voice notes, record people, take pictures, not just of you, your injuries, but the property damage, and immediately seek medical attention. It doesn't take much. And whether you're 18 or 80, it does not take much to injure you. We've seen very serious injuries occur from very low impacts. So even if you're feeling okay, go get checked out. You've got JPS Health Network. You've got Texas Health Harris Methodist Hospital in Fort Worth. You've got Medical City. You've got all these great medical providers here, but go get medical attention just to be safe, because you don't have another opportunity to do that. And then do not speak to the other's driver's insurance without talking to an attorney first. Again, call us, 1-800-THE-WOLF, or visit 1-800-THEWOLF.com. But if not me, I'm going to borrow from Clay Cooley. Shot me first, shot me last. Either way, come see Clay. Go call somebody, okay? Get some professional advice, because this is high stakes. Don't talk to the insurance company without an attorney. Talking to an attorney first. File your CR-2 with TxDOT within 10 days if no officer showed up. If the officer showed up, it's on them to do it. And then please call me. Even if you don't like me, call me and I'll get you in the right direction, just because I like you. I love everybody. But consult a qualified attorney. Reach out to a qualified Fort Worth car accident attorney as soon as possible. And there are resources if you don't know who to call. The State Bar of Texas and the Tarrant County Bar Association are both resources, or our office. We're happy to direct. If we can't help you, we'll get you to a qualified person that can.
All right. If you have been in a car accident in Fort Worth and you are not sure what to do next, make that call. You can find 1-800-THE-WOLF accident attorneys at www.1800thewolf.com, or call them directly at 1-800-THE-WOLF. The Fort Worth office direct line is 817-203-4549. Thanks for watching, and we will see you on the next episode of 1-800-THE-WOLF Accident Attorneys.